In Fulton County, Georgia, a hearing on whether to disqualify District Attorney Fani Willis has concluded today. The judge saying a verdict will arrive within the next 2 weeks. Here to discuss the legal implications is NTD's legal correspondent, Arlene Richards. Arlene, it's great to have you here with us. So what are some of the key takeaways from today's closing arguments?
Well, the defense, of course, is saying that Fani Willis tried to benefit financially from this big, sprawling RICO case. They point to testimony that she and Nathan Wade made about the relationship, which they say was not being candid with the court. They're saying that they lied, basically. They're saying that other testimony from other witnesses established that their relationship started before he was hired, whereas the prosecution says that they haven't proved a thing. The prosecution says that they haven't proven that the relationship started before 2022, as they said, because the witnesses were not very credible. So this is a very serious case. I think the judge said he's going to take about 2 weeks before he makes a decision, because this could have very serious implications for both Fani Willis and Nathan Wade in terms of their continued practice as attorneys. There are ethics issues involved here that will probably come about whether he disqualifies them or not. And that's something else that the judge will have to take into consideration. I think one of the arguments by the defense was that even under the professional rules of conduct, that this behavior of theirs in the courtroom is of legal concern. It's of legal concern, and so therefore it gives the appearance of impropriety. Now, the differences between the two sides is that the defense says that they should be disqualified just based on the appearance of impropriety, and they point to the lavish trips they took and the higher salary he received and the fact that she hired her boyfriend. But the prosecution says, well, you have to show a clear conflict of interest, and you haven't done that here. You can't point to anything here that creates a conflict of interest for the overall case, or that the defendants here have been prejudiced as a result of this relationship. So the judge is going to take a look at all of the evidence, all of the testimony that's been heard so far, as well as all of the law that has been introduced, and he's going to have a tough decision to make. So we'll have to see in a week or two what the judge decides. Steve?
Indeed, he will have a tough decision to make. NTD's Arlene Richards, really appreciate you joining. Thank you. And joining us now to assess and analyze further the arguments is Will Trackman, General Counsel for Mountain Estates Legal Foundation. Will, great to have you on the program.
Thanks so much, Steve. Great to be here.
Of course, Will. Let's get right into the substance of these closing arguments in the case to disqualify the Fulton County DA there, Fani Willis. The judge saying that the attorneys may assume cell phone records will be admitted into the evidence if they want it to be. Does that signal that he will admit those records into evidence, and how damaging might those be?
Well, the judge seemed inclined to consider everything he needed to consider. At the outset of the hearing, he was talking about how he might already have enough information, but if he doesn't, he's willing to expand the record and talk more about what evidence he might need in order to get to that decision. Those cell phone records are damning because they indicate that Miss Willis and Mr. Wade were together on a number of occasions, and the attorneys who were favoring disqualification today made the point that he couldn't identify any other reason why he was so close to Miss Willis's neighborhood so many times. I think it was something like 23 times. So without some other exculpatory reason for why he was so close on so many occasions with his cell phone, it really does draw an inference that the two of them were together and maybe engaged in activity together.
And to your point, Steve Sadow, Trump's attorney representing the former president, presented these records indicating that Wade was near the location, as you mentioned, where Willis was staying. This evidence also supports the accounts of witnesses, including Wade's previous lawyer, Terrence Bradley, and his friend, and a former friend of Willis, Robin Yurty. The judge inquired whether the defense had sufficiently met the burden of proof through a preponderance of the evidence. Based on this presentation, do you believe this defense attorney has successfully fulfilled their burden of proof today?
Well, it's a good question of which party bears the burden. So the attorneys favoring the disqualification, President Trump's attorneys and the others, were saying all you need is an appearance of impropriety. You don't need solid evidence that there was something absolutely going on. But for the public to have confidence in the justice system, they have to be able to see these prosecutors and understand that they're representing the state's interests and the interest in criminal justice, not their own personal interests, not their financial interests. And so in that case, I really did think that the attorneys favoring disqualification did a good job laying out all the potential conflicts. So there's not just the political conflict that Ms. Willis wants to bring this case politically for her own brand, but also the financial conflict that she took a vacation with Mr. Wade with money used from the prosecution, and also just generally that she had given a speech where she had referred to the defense attorneys as racist for wanting to disqualify her. So it wasn't just that they identified one or two conflicts. I think there was something like 6 different conflicts that they identified as potential. So I would definitely say they put the evidence out there for the judge. If he's inclined to rule in their favor, I think he's got the evidence that he needs.
Indeed, there were multiple conflicts, and when it comes to the monetary side, the defense contended that Willis and Wade were unable to justify the whereabouts of somewhere around $9,000, highlighting that Willis lacked any documentation for her alleged cash reimbursements to Wade. Considering this argument, your interpretation of the judge's inquiries regarding the significance of that missing amount, and at what point does the sum become substantial enough to warrant disqualification?
Well, the second question is a really good question because the parties disagreed about materiality. That is, how much money, how much financial gain has to be at play here for there to be a conflict of interest. So it's not as though Miss Willis is poor. $9,200 is $9,200, but is that enough to trigger a financial conflict of interest? But the other side of the coin is that the judge has the ability to weigh credibility as part of this process. And personally, I don't find it all that credible that someone would have $9,200 in cash and not be able to account for it, either being deposited in a bank or doing something with it. And so the judge is going to be able to consider credibility as part of his analysis. And here, that's a glaring factor that really undermines the ability of these folks to say, we're telling the truth, this cash reimbursement happened, and so there was no financial gain whatsoever. Unless you have a receipt or some other evidence that it really occurred, it's hard to believe.
Well, the defense lawyers contended that the affair between Willis and Wade was strategically planned for Willis's advantage, alleging that they engaged in fraudulent activities involving the court when their relationship was discovered, particularly concerning their cash transactions. So the defense argues that these actions constitute part of a broader pattern of misconduct, warranting their dismissal from the case. How convincing do you find these arguments?
Well, the key question in all of those is there a conflict of interest? Are the prosecutors acting on behalf of the state and in the interest of criminal justice? Or, on the other hand, are they acting in their own personal interests? And so to the extent that Mr. Wade is getting paid with government dollars in order to take vacations with Miss Willis, that's a conflict of interest. And I think the judge here is going to weigh, again, the materiality, how much of a conflict is this, and what is the appearance to the public? Because even if at the end of the day, the prosecution is able to say, look, they haven't proved necessarily that there is a financial benefit to this case, it's still the ability of the judge to disqualify Mr. Wade and Miss Willis on the basis that there's an appearance of impropriety. The public needs to have confidence in our justice system in order for it to function appropriately. And without that confidence, it just won't work. And so here I think the judge is going to think, the conflict exists because of all these different factors, and there's no way of disproving the appearance of impropriety.
So Trump attorney Steve Sadow highlighted Willis's second ethical breach, emphasizing doubts about their honesty regarding the affair's timeline, urging the court to trust Terrence Bradley's text messages as accurate evidence and raise general concerns about their truthfulness. Based on this, do you believe the evidence presented is sufficient to meet that required proof? And I also want to ask, I think, a more important question, which is when it comes to the judge there, he's in a rock. He's in between a rock and a hard place, really, in making this decision. How do you see him ultimately, handing down any type of decision here?
Well, the judge is a good judge. He's making the right record. He's asking the right questions. He's very clearly going to think through this. A lot of the time, judges make decisions from the bench. Here, I expected the judge to make a decision from the bench, and he didn't do that. He said, I need time to contemplate all this evidence. I need up to 2 weeks in order to make a ruling. You know, the interesting thing about Terrence Bradley, the divorce attorney, is that he had these text messages that are in the testimony, except his live testimony was completely different. He said, "I can't remember. I don't recall sending those text messages. I don't remember the conversation that I had. I don't know when the affair started. I really don't know anything. It's all speculation." And so here it's going to be up to the judge to weigh the hard documents, the text messages that definitely exist, with the testimony that occurred before his very own eyes. And he's again going to be able to make credibility determinations as to whether Mr. Bradley was being honest. But here I do think the defense attorneys, the ones who are seeking disqualification, made a good record that those text messages do indicate that the relationship started much, much earlier than Mr. Wade and Ms. Willis allege.
Attorney Will Trackman, really appreciate you joining.
Absolutely. Thanks, Steve.
Former President Trump today appearing in a Florida court seeking to push back his classified documents case. His lawyer asking the judge to delay the trial until after the general election. The trial is currently set to begin on May 20th. Federal prosecutors sought to push it back to July 8th, just 1 week before the Republican National Convention. But Trump's lawyers said the former president can't have a fair trial while campaigning. They also argued that it would be unfair to prepare for the classified documents trial amid the ongoing hush money case in New York. Today's ruling ended without the judge setting a new trial date. Trump faces several counts of willful retention of national defense information and obstruction. His co-defendants face obstruction charges as well. All three have pleaded not guilty. Thank you for watching the Capitol Report. If you want to see our full broadcast, check us out at epochtv.com.